Every society depends on a shared illusion called law. We tell ourselves that rules, not personalities or factions, decide our disputes. When that illusion holds, even bitter rivals can coexist because they agree on the referee, if not the result. When it cracks, everyone scrambles to build a ring of their own, each side claiming fairness but meaning, in practice, fair for us. That shared illusion is not naive faith in perfection. It is faith in a discipline, the idea that fairness arises from following the same rules even when those rules fail us. In constitutional systems, neutrality does not mean that decisions are free of bias or power. It means that the procedure itself, rights of evidence, appeal, and due process, is what binds us when outcomes cannot. Neutrality is not a description of reality. It is a covenant of restraint, a collective promise that no side will rewrite the rules mid-game. It is the structure that lets injustice be corrected without destroying the system that corrects it. When people lose confidence in that covenant, the drift begins. The trigger is rarely cynicism, it is frustration, the sense that official processes are too slow, too cautious, too compromised by the wrong values. Reformers don't start by rejecting neutrality. They start by insisting that neutrality has failed and that justice requires new procedures, special forums, special rules, special urgency. But in doing so, they replace the idea of shared discipline with the idea of chosen process. Once you teach people that justice depends on picking the right procedure, you also teach them that losing in the wrong one isn't justice at all. From that point on, every defeat is proof that the forum itself was rigged. What began as moral impatience ends as institutional exhaustion. The claim is simple enough to fit in one line. When groups abandon shared procedures in favor of ad hoc venues that deliver favored outcomes, they redefine justice as choosing your own process. That lesson, once learned, spreads, and soon every faction builds its own court. This drift doesn't look like a revolution. It looks like paperwork. It feels like compassion. It often begins with a cause that seems unassailable, protecting victims, speeding reform, cutting through bureaucracy. But the underlying mechanism is always the same: process substitution, the replacement of neutral, rule-bound procedures with tailored forums justified by urgency or identity. The results are predictable because the logic is recursive. Once one side changes the rules, the other side's best reply is not to defend neutrality, but to build its own exception. Soon their process and our process replace any notion of a shared process at all. In game theory, this is called strategic complementarity. Each deviation rewards the next. In social life, it's called reciprocal radicalization. You can see the pattern in every domain that has bled public trust: universities, newsrooms, politics, and the digital commons itself. Each once claimed to stand above faction, governed by rules rather than sympathies. Each then faced a reckoning, charges that its neutrality masked privilege or power, and each, when confronted, responded not by repairing the shared rules of judgment, but by building alternative forums to handle the grievances directly. In universities, grievance offices and Title IX panels were created to bypass courts thought too remote or re-traumatizing. In journalism, editorial standards gave way to internal reviews and public editors who judged stories through moral frameworks of harm and impact. In politics, parties replaced deliberation with ethics committees and investigative task forces, each tailored to adjudicate their own scandals. Even social media adopted the form. Trust and safety boards, content tribunals, and community guidelines became miniature courts of conscience, issuing verdicts at the speed of outrage. In the short run, these experiments delivered results that felt overdue. Victims were heard, misconduct was punished, marginalized voices gained standing. But the mechanism mattered as much as the mission. Each reform reinforced the same hidden lesson. That fairness depends less on what rules say than on who enforces them. Once that idea took root, every faction learned to build its own forum, its own code, its own appeal system. The cycle closes when those who first demanded exceptions find themselves summoned before exceptions of another kind. The journalists once trusted to judge others are judged online. The campus activists face their own disciplinary hearings. The politicians who created new investigative boards are investigated by them. The symmetry is perfect and corrosive. Each side vindicated by its own process, each convinced that the other's is illegitimate. What began as reform ends as recursion, an archipelago of procedures, each claiming to be the real one. At the root of this descent lies a simple causal chain, what we might call the causal triad. Procedural legitimacy erodes when people stop believing that rules apply equally. That loss leads to process substitution, new, bespoke forums that promise speed or empathy. These forums solidify into exceptional systems that now compete with the institutions they were meant to supplement. It's a chain reaction. Legitimacy loss creates substitution. Substitution creates exceptions. Exceptions further erode legitimacy. What feels like moral progress is, structurally, the start of fragmentation. The early 2010s were not just a moment of regulatory adjustment. They were the hinge on which the culture of higher education turned, from institutions that adjudicated cases to institutions that managed climates. It began with the 2011 Dear Colleague letter from the US Department of Education's Office for Civil Rights. The directive required colleges and universities to handle sexual misconduct cases under Title IX, using the preponderance of the evidence standard and operating through campus grievance procedures rather than the criminal or civil courts. The purpose was humane, to make redress accessible for victims who had long faced dismissal or disbelief. But the mechanism mattered as much as the mission. Overnight, universities were not just educational or disciplinary bodies, they were quasi-judicial systems, complete with investigators, compliance officers, and internal tribunals. They developed a procedural world that ran in parallel to the justice system, but operated by different rules: lower evidentiary thresholds, restricted cross-examination, limited discovery, and a bureaucratic emphasis on risk containment. Once that machinery was built, its reach could not be confined to sexual misconduct. The same offices, compliance logics, and investigative templates were soon applied to speech, expression, and interpersonal conflict more broadly. What counted as hostile environment or harassment expanded from physical acts to words and ideas. In effect, the system that had been justified by the urgency of protecting victims became a general instrument for policing discomfort, dissent, and reputation. Within a few years, campuses were running continuous adjudication loops, not occasional hearings, but rolling reviews of emails, posters, social media posts, classroom remarks. Every domain of university life now fell under procedural management. A university no longer merely punished misconduct, it administered community sentiment through process. The effect was cultural as much as bureaucratic. A generation of students came of age inside institutions where the line between moral harm and procedural violation had blurred, where justice meant finding the right administrative forum, and where outcomes were legitimate if the chosen process had delivered them. That is how process substitution became a social intuition. Whether one saw the change as overdue or overreach, the lesson absorbed was the same. Justice is not a neutral rule, it is the right venue. By the middle of the decade, those same students were carrying that procedural reflex outward into workplaces, media organizations, and activist movements. They had learned that when an official channel seems biased or slow, the answer is to create a new one. An independent review board, a public statement, a Slack investigation, a social media campaign. Social platforms turned this reflex into spectacle. The call-out, the open letter, the viral thread, all followed the same logic as the campus tribunal. They were alternative adjudicatory spaces, operating by new norms of evidence, accountability, and remedy. The feed replaced the courtroom, the ratio replaced the verdict. The moral energy behind these acts was genuine, often redemptive. But the structural effect was unmistakable. Every new forum of conscience normalized venue selection as virtue. Outcomes justified forums, forums defined fairness. Once that equation took hold, any institution that resisted exceptional process looked corrupt, and any faction that embraced it looked righteous, until the cycle turned and another forum rose to judge the last. Every political community has its moment of recognition, the realization that rules no longer settle fights. At first, this feels liberating. When you can't trust the old procedures, building your own feels like progress. But the liberation is temporary. Once one faction learns to win by changing the rules, every faction must do the same. This is where the reinforcement triad begins, a closed loop of cause and effect that locks institutions into cycles of polarization. Exceptional forums spark strategic complementarity. The logic of if they can, we must. That complementarity produces legitimacy loss, since every defeat can now be dismissed as their process. The resulting distrust reinforces the creation of new exceptional forums. In logical terms, the cycle is self-sealing. In cultural terms, each faction's attempt to protect fairness accelerates the collective loss of it. The campus-era procedural experiments offer a vivid example. Once schools began running internal trials under lower evidentiary standards, opponents quickly framed those systems as kangaroo courts. Lawsuits followed, courts split, rules shifted. When one circuit demanded live cross-examination, while another permitted written summaries, it signaled that even law itself no longer agreed on what due process meant. This inconsistency did not just frustrate administrators, it trained a generation to see rules as partisan artifacts. If legal legitimacy depends on jurisdiction, and moral legitimacy depends on venue, then both can be chosen strategically. Fairness became something to shop for. Soon this reflex escaped the academy. In politics, in journalism, in activism, groups built their own procedural infrastructures, independent investigations, selective leaks, tribunals of conscience, special task forces. Each was justified by urgency, yet each taught the same deeper lesson, that the ordinary process cannot be trusted. In game theory, strategic complementarity means that one player's deviation makes another's deviation optimal. Once one actor defects from the shared rule set, restoring neutrality unilaterally becomes self-defeating. This logic explains why procedural polarization never burns out on its own. If one side builds a special forum for its grievances, the other cannot return to a neutral forum without appearing naive or complicit. Both sides therefore mirror one another's exceptions. One justifies emergency measures to achieve justice, the other justifies emergency measures to restore order. Each believes it is responding to abuse, both are accelerating mutual delegitimization. The result is not chaos, but a highly structured arms race of exceptions, where the only remaining consensus is that there is no neutral ground. As the cycle matures, institutions themselves are drawn into the performance. Courts, universities, newsrooms, and agencies no longer operate primarily to decide disputes, but to signal loyalties. The content of their verdicts matters less than the audience they play to. Hearings become theatre, votes become choreography. Press conferences replace deliberation. Procedures, once designed to filter out emotion, now exist to display it. This is not hypocrisy, it is adaptation. In an environment where legitimacy comes from your followers, not from your procedures, the rational move is to act for applause. Institutions that were designed as referees now behave as contestants. Every round of procedural escalation drains a bit more public faith. Each new exception creates not only a counter-exception, but also a layer of fatigue. Ordinary citizens, no longer sure which forum counts as real, begin to tune out. That disengagement is often misread as apathy. It is actually a rational defense against incoherence. When every outcome can be reversed by moving to a different process, why invest emotional energy in any of them? This brings us to the final triad in the drift, the non-linear triad, the phase in which loss of legitimacy produces not rebellion, but exhaustion. When trust in procedure collapses, what comes next is not open revolution but slow suffocation. Institutions keep operating, people still show up to hearings, sign forms and issue statements, but something essential disappears. The belief that any of it means anything beyond choreography. This is the non-linear triad at work, a dynamic in which every effort to restore legitimacy by force only deepens the fatigue it was meant to cure. Legitimacy loss prompts stronger efforts at control. Control measures, new rules, compliance systems, loyalty tests, further alienate participants. Alienation then accelerates disengagement, which makes coercion seem necessary again. The logic is self-consuming. What looks like reform becomes maintenance. What looks like order becomes entropy management. Institutions rarely acknowledge that their authority has eroded. Instead, they compensate by multiplying procedures. New committees to review old committees, new codes to clarify the old codes, new oversight boards to ensure that the rules appear to work. The impulse is understandable. Do more, regulate more, enforce harder. But each additional layer communicates a hidden message. We don't trust ourselves either. Over time, compliance replaces conviction. People stop doing the right thing because it's right. They do it because someone might be watching. Ironically, this bureaucratic thickening is the inverse of the crisis that began it. The system that once abandoned neutral process for flexibility now drowns in process as performance. Both are symptoms of the same disease, the loss of shared belief that rules in themselves can be legitimate. When persuasion fails, power fills the gap. Officials who sense waning authority reach for sharper tools: disciplinary boards, speech codes, executive orders, emergency powers. The stated aim is stability. The real function is enforcement without consensus. But coercion carries diminishing returns. It can make people obey, but it cannot make them believe. Worse, it invites moral inversion. Those punished under the new rules claim martyrdom, and the enforcers, already distrusted, look tyrannical for applying the very procedures they themselves reinvented. At that point, process has lost not only neutrality but moral gravity. What remains is the appearance of law. Hearings without persuasion, investigations without closure, verdicts without legitimacy. Eventually, the public adapts in the only way that preserves sanity: withdrawal. People stop expecting institutions to deliver truth or fairness. They expect only partisanship. They participate selectively, if at all, and interpret every decision through the lens of tribal affiliation. In this landscape, cynicism is not a vice but a survival strategy. When everyone knows that justice depends on choosing the right forum, abstention becomes the rational choice. The burden of legitimacy shifts from institutions to individuals, each constructing private moral microcosms, personal news feeds, curated facts, chosen courts of opinion. What began as an attempt to democratize justice ends with the privatization of belief. Institutional exhaustion doesn't look dramatic. It looks quiet, procedural, and vaguely professional. Meetings still happen. Policies still change hands. But beneath the paperwork lies stasis. Because no rule is trusted to endure, every decision becomes provisional, something to be reversed when the other side's forum gains control. The system continues, but only as a kind of maintenance loop. Coercion sustaining order, disengagement sustaining coercion. The underlying society ceases to generate legitimacy. It merely administers compliance. This is the endpoint of the drift that began with process substitution. A culture where rules no longer bind us when they hurt us, and therefore no longer protect us when they should. Pluralism survives only under one condition: that the rules bind us when they frustrate us. Shared procedures are not a bureaucratic luxury, they are the infrastructure of coexistence. Every generation must relearn this, because every generation is tempted to believe that its cause is urgent enough to justify exceptions. The real wisdom lies in resisting that temptation, understanding that the slow, impartial process is not the enemy of justice, but its most reliable friend. Fairness that must be fast or favorable will eventually serve neither. If the last decade taught us anything, it is that process is culture. Once we redefine justice as the right process for our side, we teach everyone else to do the same. Once we restore the expectation that the same process applies to all, even when it fails us, we begin to heal the civic fabric that fragmentation frayed. Legitimacy is never permanent. It is something we have to keep making, an act of discipline, not faith. It is produced by restraint, by choosing to submit to the same rules that restrain others, even when breaking them would be easier. That choice is the quiet test of every free society. A democracy endures not because it always decides rightly, but because it convinces its citizens that losing fairly is better than winning by exception. The moment we stop believing that, the rule of law becomes theatre, and every dispute becomes a contest of power. What holds a plural nation together is not shared opinion, but shared procedure. The willingness to let the same rules bind us when they wound us, as when they protect us. Rules are not a cage we live inside. They are the structure that keeps us from devouring one another. They are how free societies stay free.